Mohamed.
Thank you, Mr. Stringer. It's a pleasure to serve with you in the chair. I would like to begin by thanking my honourable friend, the member for Upper Barn, for securing this debate on the first anniversary of the Four Women Scotland versus the Scottish Minister's ruling. I also thank her for her work and that of other colleagues in this chamber that are present today as well on these sensitive issues surrounding sex and gender, and they have helped ensure that Parliament continues to grapple with these issues in a careful and thoughtful manner. Mr. Stringer, this issue has faced our society before I became a member, but even before I entered this place. It was clear that it's been weaponised against one human being against another by people who not always have the best interests of those groups or human beings at heart. And I'm struggling to put into words my complete confusion that in the 21st century, in the UK Parliament, we are debating what a woman is. Adam and Eve, if you are people of faith or believe in the origin of human beings, or if you're not people of faith, people have known what a woman and a man in since the beginning of time. Now, I stand here with full respect for those who feel or want to be, or for whatever reason that I don't understand, believe that they are a different gender to the biological sex that they are in. However, women's rights have been less and diminished for centuries, and every single year they're fighting on many fronts for equality. I've stood in this very chamber and in the main place talking about women's rights on healthcare, on maternity rights, on gender equality pay, on things that men have taken for granted and imposed a substandard level of right on women. It's completely unacceptable. But here we are now, we're questioning the fundamental biology of women, not just in this place, in this country, but everywhere in the world. And I can't reconcile the situation that we faced. So when the Supreme Court finally gave a ruling that clearly defined what a man and a woman is under the law, we expected this gaslighting, this aggressive lobbying, this fighting between fellow human beings to hopefully recede with clear guidance, clear rules, clear processes, both at parliamentary level, at legal levels, and at employment rights levels. But here we are a year later, and the government has been dilly-dallying and sitting on the ruling, which does not change the law, as my honourable friend from Canterbury has said. So, the anniversary provides an opportunity not only to reflect on the nature of this specific ruling, but to reaffirm the fundamental principle that in a democratic society governed by the rule of law, the judgments of our highest courts must be respected and properly implemented. The Supreme Court's ruling of 16th of April 2025 brought much-needed legal clarity. It confirmed that within the meaning of the Equalities Act 2010, references to sex, man and woman, are to be understood as referring to biological sex. How somebody felt that they referred to something else, I cannot understand. That was not the creation of a new law, but the authoritative interpretation of legislation passed by Parliament. I stand here with women constituents, men constituents, trans women constituents, trans male constituents, and people who are still trying to find their way through their biology and feelings. And I stand for each and every one of those without fear or favour. I've met trans people in my constituencies, both who have transitioned fully, so they are either a man or a woman, because biologically they have transitioned. And those that have not transitioned and have a gender recognition certificate or live their life as the opposite gender. I haven't met, and I have not met many of you. I will give way.
I thank the Honourable Gentleman for giving way. Everyone's been very generous with their time today. I'm very grateful. He said that they have transitioned biologically. I thought biology was either one thing or the other and was immutable. I was wondering if he could explain that point.
So I'm not a medical doctor, and there are experts in this room. But for me, if somebody has gone through operations through the NHS, which is medically assessed and professionally delivered, I respect their current biological status. So if I've used the wrong language, I apologise. But these are special cases. The case that the Honourable Member mentioned earlier in an intervention, where somebody has had breast cancer and had a double mastectomy and may be misidentified as male, that is a special case. That person has gone through a physical change that may make others see something different to who they are. So those are separate arguments to biological males identifying as women. So I was just saying, so these transgender constituents of mine, none of them have come to me and said, I want to be entering private spaces or single-sex spaces of the other gender to make me feel that I am who I believe that I am. And I think this needs to be understood, that this view isn't universal across the transgender community. So clarity in the law is profoundly important. Without it, public bodies, service providers, and indeed individuals are left navigating uncertainty. Inconsistent interpretations risk undermining both compliance and confidence with our legal system to distressing effect. Rights that already exist in law for any gender, biological sex, man or woman, they cannot be usurped by new demands by people in our community, whether it's trans, whether it's Muslims, whether it's Christians, whether it's people of no faith. Rights, once they're acquired and in law, should be protected and implemented. And any new demands or changes required to support in full other members of the community who may differ have to be grappled with and dealt with by the government without undermining existing rights that exist. The court's judgment provides a clear, coherent framework within which decisions can be made, particularly in relation to single-sex services, which the Equalities Act explicitly permits. Yet this judgment did not remove the rights from trans people. Protections preventing discrimination remain firmly in place, as they should. Trans rights are human rights where they are not impinging on somebody else's human rights. And that is a really clear distinction that we need to make. This is not a zero-sum question of one group's rights being set against another's, with gains for one group coming only at the expenses or at the loss of the rights of another. Rather, it is about ensuring that the law is applied as intended, recognizing distinct protected characteristics and giving effect to each in a way that is workable and crucially fair. Of course, implementation must be done sensitively and responsibly, taking pains to ensure that the human rights and dignity of all are respected. The law already allows for flexibility to accommodate this. So it's really, really difficult to understand why the public sector, especially in the NHS, and I want to pay tribute to the Darlington nurses and Jennifer Melley for being here and for being the sort of light or the source of information around this topic, but going through so much suffering and persecution to stand up for their basic human rights as biological females. So when the NHS are spending hundreds of thousands, if not millions of pounds, going to tribunals, knowing that they're going to lose for an ideological, entrenched reason, that should not be happening. That money should be spent treating women, trans men, and other patients within the NHS. So,
Can you give way on that point?
I will give way.
He's talking about the way care is mentioned is managed within the NHS, and I just wondered if you thought about the the way it's important to ensure for trans women and trans men that their biological sex is known by the clinician who's treating them, because if they're on a ward, well, there will be a presumption made that they're the same sex as the other people on the ward, which could leave them in a difficult position medically. If they receive a blood test result, perhaps for a haemoglobin, then it will be interpreted on the sex that they understand the person is, which could lead to an error if that is not the sex the patient actually is. When patients are invited for screening, they need inviting for the right type of screening and not the wrong type of screening for their own safety. And when statistics are produced that help with epidemiology and further healthcare, they need to be done in a way that is accurate.
Iqbal Mohamed.
I thank my honourable friend for her intervention and her expertise in this area. So recognising biological sex is in the interests of trans people as well. We are not just different on the outside, we are different on the inside. And hospitals need to be able to treat people for who they are, not who they believe they are or who they want to be. And we could end up with mistreatment, misdiagnoses and further litigation against the NHS for causing harm to somebody because we didn't take into account explicitly their biological sex. So the law already allows flexibility to accommodate the implementation of human rights for all. It permits the provision of single-sex services where justified, while also enabling appropriate alternative arrangements, such as unisex facilities, where these are needed to ensure that everyone is treated with respect. But the clarity in principle that this ruling provides must now be matched by clarity in practice. We are seeing now a move from organisations. The IOC announced recently that they will not allow non-biological women to compete in women's sport. The Girl Guides have now updated their guidance to go back to, separating or admitting guides based on biological sex. This is not discrimination against the trans people. It's just common sense and the protection and implementation of existing rights for girls and women. So, in that spirit, I would like to ask the Minister 3 specific questions. Firstly, what steps is the government taking to ensure that public bodies and service providers are not delaying implementation of this judgment under the mistaken belief that they must wait for further guidance before acting? The Supreme Court ruling was black and white and gave all employers, the public sector and sporting bodies enough information to proceed with implementing the ruling. Secondly, how the government intends to support service providers in striking the balance between single-sex and unisex services in practice, particularly in frontline settings such as healthcare, education and local authority services, where the consequences of uncertainty are often felt most acutely. And finally, can the Minister set out how the government intends to communicate clearly with the public about what this judgment means in practice, so that both women and trans people understand their rights and protections under the law? As legislators, we have a special responsibility to ensure that the law remains coherent and relevant to the world we live in. So 1 year on, I hope that the message should be clear. The law has been clarified. The rights of women to access single-sex services are justified and recognised. The protections afforded to trans people remain in place, and the responsibility now lies with all of us, whether that be the government, public bodies, parliamentarians, employers, sporting bodies, or any other group, to ensure that this clarity is translated into consistent, lawful practice. Thank you.